Hello, my name is Olu Osha. I like talking about American presidents. I'm continuing with my discussion on, uh, defenses to second degree assault, and specifically intent to frighten assault, which sometimes is conflated with attempted battery. In a state like Maryland, for instance, they don't have a distinction between a battery and second degree assault. An assault where a battery occurs, that's an offensive touching. It's normally categorized as a second degree assault, and it's a first degree assault, felony assault, when a dangerous weapon is used, right? And there's actually an offensive touching, right? There's contact, and then that's a first degree felony assault. But in a state like Maryland, um, it's this huge umbrella, a second degree assault, and it's got different modalities and their statutory elements. So in this case, I'm focusing on intent to frighten assault, which of course there doesn't have to be touching, and the statutory elements are one. There's a threatening act. A threatening act can be raised fist, brandishing a knife, right? Without any touching. Remember, there's no touching, there's no contact in intent to frighten assault. And then there's got to be a second element, that's the specific intent to create fear in the victim, right? That there's going to be impending, there's imminent injury, there'll be immediate bodily harm, even though the bodily harm, the contact does not occur. So the result of an intent to frighten second degree assault would be fear, right? The fear. And then the third element is that in terms of the victim, they've got to have a reasonable apprehension of imminent bodily uh, injury, right? Imminent bodily contact, imminent bodily harm. It's got to be reasonable, and it's subjective, right? It's subjective uh, based on the circumstances uh, of the victim, and it's reasonable in that somebody else in the victim's shoes would feel that reasonable fear as well, would reasonably experience that fear as well. Now, I did an earlier video in which it was that was a federal case. I was discussing a federal case. That was a case of United States versus Acosta Sierra, and in that case, the Court of Appeals reversed the conviction of the defendant because the jury instructions did not adhere to the statutory requirements in this specific instance of causing the existence of a reasonable apprehension of impending bodily injury, right? So there's that in this instance, the police officer, the federal agent, he didn't, a stone had been thrown at him. It didn't hit him. It went over him, just by him, and he didn't realize it. He never saw the defendant. That's Acosta Sierra. He never saw him doing the act. He didn't know he actually did it. He only realized it after the stone had fallen to the ground, and he saw the stone, and then he looked back, and that was when he saw the Acosta Sierra. That's the defendant. So he saw him post the threatening act, not not during the act or before the act. So he didn't have so the courts felt he didn't, that the victim didn't exhibit um, the the requirement of reasonable apprehension of imminent bodily harm. So the imminent bodily harm is supposed to be at or before the threatening act, right, or as it's about to happen, not after it. So you see, in the federal case, that's this case that I just discussed and I discussed earlier in detail. It shows how the federal court um, we're sticking to statutory elements of an intent to frighten assault, of second-degree assault, intent to frighten assault, or a form of assault that's supposed to cause fear, create fear. Its equivalent, of course, is in Maryland, the state of Maryland, and it's called second-degree assault, specifically intent crime, intent to frighten, also called an intent to frighten second-degree assault. However, while there's statutory elements as well, the statutory elements in Maryland, they're similar. We find that in a case called Barrington Dean Watts versus State of Maryland, which is a 2018 case, we find that 2017, and then it was appealed. Upon appeal, it was the Court of Appeals affirmed, and we find that the state of Maryland, their courts do not focus on the modalities of second-degree assault like the federal courts demonstrated in United States versus Acosta Sierra. So the state of Maryland focuses more on the act of violence, and so they treat second-degree assault as one unified assault, and they don't require unanimity from the jury regarding the modalities or the specific forms of assault. For instance, they won't require the jury to vote unanimously regarding a specific intent to frighten assault versus a battery, right? A battery assault. So long as assault happened, right? So some people can vote, can believe that, well, it was a battery that occurred. Some people couldn't believe that it was an intent to frighten assault that occurred. And so long as they all are unanimous that a form of assault occurred, then the courts won't make that distinction regarding the modalities for assault in the state of Maryland. So they conflate everything. So that makes it sort of, convoluted. That's another big word. It makes it sort of, vague, at least with respect to the way the federal courts see second-degree assault and the modalities. Because what is the purpose of having statutory elements, right? The requirements. What's the purpose of saying, well, for an intent to frighten assault, there are these three elements that have to satisfy it. That there's got to be a threatening act. That there's going to be an intent. That's mens rea, an intent to create fear, right? Then the third one, that there's got to be on the part of the victim a reasonable apprehension of an imminent bodily harm. So what's the purpose of having those three elements if they're saying, well, you're not going to provide the jury instructions to be able to make those distinctions, but they just have to agree on, well, some form of assault happened. It doesn't matter if some people think, well, it was a battery that occurred, and some people think, well, it was a second degree, it was an intent to frighten assault that occurred. Each one has one vote. They can vote unanimously, even though they think different modalities of assault occurred, right? So that's the challenge. That's the, the federal court would see it differently, and we see that in the earlier case that I discussed in an earlier video. That's in United States versus Acosta Sierra. In any event, so now I'm going to discuss some of those defenses to assault. I want to do entrapment later on because that applies to my case. And importantly, because the location of the assault on the alleged assault on a police officer is very important. Like in my case, for instance, I was in my home. There was no arrest warrant. I'm going to remind us again of the Fourth Amendment. The Fourth Amendment protects us, and the 14th Amendment as well, due process of law. So the Fourth Amendment, what does it say? Again, I'm going to repeat it. We can't repeat it, too much. We can't recite it too much, so I'm reciting it now. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Again, I've done earlier videos, none of those requirements were met. Probable cause did not exist. I was in my home. I have a right to be in my home, right? To be free from to be free from being at the mercy of the whims and caprices of cops, or they might be rogue cops, because this is our home. Our home is our castle, and I'm going to describe how the castle doctrine is actually a defense when there's no Fourth Amendment, when there's a Fourth Amendment violation. Again, probable cause. What's probable cause? That's a very important element that's required before a judge can actually give an arrest warrant. Because remember, there's some exigencies. I'm not going to confuse us by talking about exigencies today, but let me just remind us of the Fourth Amendment and probable cause. And what's probable cause again? Probable cause, I like probable cause from the case Brenniger versus United States. It's a 1949 case, and it says the facts and circumstances within the knowledge of the officer with reasonably trustworthy information sufficient to warrant a belief by a man of reasonable caution that a crime is being committed. So that's probable cause. Again, the facts and the circumstances within the officer's knowledge with reasonably trustworthy information, right? So somebody tells the officer that there's a crime going on. It's reasonably trustworthy, right? It reasonably trustworthy, to sufficient to warrant a belief, right? There's got to be a reasonable belief to warrant a belief by a reasonably caution, by a man of reasonable caution. It could be a woman, but these old judges, these old jurists, right, in their opinions, I'm reciting a jurist's opinion, and this is how they wrote back then. So a man of reasonable caution to that a crime is being committed, right? So let me repeat it again. By the way, so there's this standard reasonably prudent man, right? The reasonable man, that's from tort, and you see a lot of the assault definitions and principles and models are also related to tort. So you come across it. You come across these definitions in tort as well, tort law, but this is criminal law, right? So let me repeat the probable cause standard again from Brenniger. It's from Brenniger. So probable cause is the facts and the circumstances within an officer's knowledge with reasonably trustworthy information sufficient to warrant a belief by a man of reasonable caution that a crime is being committed, right? So I was not committing any crime. I was in my home, right? I have evidence I wasn't committing any crime. I was in my home where I have a right of usufruct. Right of usufruct is your right to enjoy your property you're renting, right? The lease was in my name, right? I had a security deposit. My lease wasn't expired. Still several months, I'd been living there for 2 years. It was in my name, and I lived alone. It was a place I had a right to be in. There was no arrest warrant for me, nothing, right? And the cops just come on a pretext, right? On a pretext that somebody says something, I have no idea what the person said, but the police took certain actions. I'll do that when I get into the entrapment portion. But let me quickly say what the regular defenses that we have for intent to frighten. A defense can be, it was an accident, right? The actions, so again, remember in second degree assault, there's no battery, there's no contact, right? There's no offensive touching, there's no bodily harm, right? Nothing happened. But there was a threatening act, so it could be maybe the person the offender or the actor was brandishing a knife, right? So that can be the that can be the offensive act, the threatening act, or he was raising his fist, so that could be a threatening act. So a defense can be it was a mistake of fact, right? I've done videos explaining what can be an example of a mistake of fact, or it could be an accident, right? That's a defense that negates the criminal intent element. So you want to show there's no mens rea, because that's very important in an intent to frighten assault. You want to show there's no mens rea, there was no criminal intent, or you were joking, right? You were play wrestling, and so that's that. Play wrestling, well, there's normally contact, but maybe you pretend like you were gonna hit somebody, right? If while you're play wrestling, right? So then that's there's no intent, there's no criminal intent, there's no mens rea because you are joking. Or it could be consent, right? Because if you're play wrestling, you have consent that, okay, hey, you guys, you're in sports, it's a contact sport. Maybe there's no contact, but they're approaching you like they're gonna in a threatening position, and so there's that threatening act, or maybe you're fencing and you're acting like you're about to stab them with the with your fence or your sword or whatever, and so but that's you because you're playing sports together, and so you've given your consent. So consent, accident, mistake of fact, and self-defense, right? Self-defense is actually self-defense is is a valid defense to use when you're in your home, right? In my case, I was in my home. So in your home in Maryland, there's something called the castle doctrine. Your home is your castle, and in the state of Maryland and many states as well, you're entitled to defend your home against uh, imminent against an armed intruder when you fear a threat to your life or bodily injury. So you can defend yourself. You're entitled to self-defense, even up to using deadly force. So self-defense is a defense against assault, or in Maryland, and that's under the castle doctrine. But importantly, you can't be the aggressor, right? The defendant cannot be the aggressor. He's totally acting in self-defense, right? So they came at him and he feared for his life. He can't be the one who instigated the aggressive act or the violence. Again, in the state of Maryland, their focus on the second degree assault there is they're totally against the act of violence. That's what they're trying to punish and deter, right? Then I want to discuss entrapment as a defense. Entrapment is a defense. So for entrapment, again, this goes back to Oliver Wendell Holmes's theory that although that was with regard to fruit of the poisonous tree, right, where the government gets evidence from your home illegally without a warrant, right? They do something illegal to obtain warrants, but it's still the same idea, right? It's still the same idea that the government can benefit at trial from something from government misconduct, right? So Oliver Wendell Holmes had said, it is a lesser evil for some criminals to escape than that the government play an ignoble part in, violating the constitutional rights of a defendant, of an American. So when the government entraps you and snares you to commit a crime, they're targeting you, right? So that's a violation of your 14th Amendment rights, right? Your equal protection of the laws. They're targeting you, and then the government is doing something ignoble, something disgraceful. They're not supposed to be inciting crime in your home, right? Especially you're in your home. But there are many things that you have, there are requirements, and there's some complexities to using entrapment as a defense. One, it can mean sometimes that the defendant is having to admit that they committed, if not the whole crime, at least elements of the crime, right? So that's one challenge. And but importantly, they also have to prove government misconduct, that the government misconduct was very outrageous. There's a subjective part as well, that the defendant has no propensity to crime, right? The defendant is a law-abiding person. They're clean. They're like a churchgoer. They're law-abiding. They actually work for the federal government, right? And they're clean. Imagine somebody who works for the federal government themselves. Then it would be very difficult for the police. It'll be very difficult for the police to be saying that the person is a criminal and they need to put them away, especially if it's in their home. So they have to, the subjective element, they have to be able to show that they have no propensity for crime. They're very clean, right? And the other thing is the objective part. Some states focus on the objective part. That is, that the government, their conduct was so outrageous, that they coerced the defendant into, committing the crime, into, engaging in what they're now charging, alleging is assault. They're the ones who provoked him, they induced him, they ensnared him, they orchestrated everything, right? So, and the harassed and the provocation was so egregious, it was so outrageous, right? And that without this inducement by the government, they would not have committed the assault, right? They would not have done where it is. So, for instance, if the police is locking you in your home, blocking your peephole, and they're gaslighting you, they don't tell you why you're there. They make you fear for your life. They're tricking you, or they orchestrated a hoax, like they did for me. Like the Navy and the police, they orchestrated a hoax to make it look like, well, I was going through this military training exercise to join military intelligence. They sent me an email, planned it ahead of time. Fortunately, I had the email. And then they locked me in. And then the police go and spread information to my neighbors and evacuate the building that I'm actually a criminal who's holding a woman hostage. So that when I'm banging on the door, nobody comes out. They block my people. They're surveilling me with a drone. There's no arrest warrant, nothing. They just come. So that's outrageous government conduct. Like, that's gaslighting. In fact, the gaslighting in the state of Maryland is criminal. You gaslight and it causes injury, it's criminal. And that was what happened. So the police actually engaged in a criminal conduct because they gaslighted me, and eventually they injured me because they tasered me and they shot me in the head, and I have stitches there. So that's when you can use entrapment. The conduct of government is so outrageous. You have no propensity for crime. You would never have committed the crime. They're trying to ensnare a law-abiding person, and it's in his home, right? And without the government's inducement, you would not have fallen, so it ended up being an involuntary action. It was reflexive. It wasn't a voluntary action, right? Normally, when I talked about actus reus, like the act, one of the elements of a crime, for instance, it's got to be mens rea, the criminal intent in the mind. And then there's actus reus. So if the actus reus is there, the actual, for instance, actus reus in second-degree assault would be a threatening act. So if it's there, but the thing is, it's got to be voluntary. Actus reus is supposed to be something you did voluntarily, right? But if you were induced, you were gaslighted, and it was reflexive, then it's not voluntary. So that's when entrapment is a good defense that can be used, right? When there's outrageous government action that they compelled you, they coerced you, induced you, their outrageous conduct compelled you to act in a reflexive manner, right? And you have no propensity to commit crime. You have no propensity. You're a law-abiding, citizen. So that's when entrapment is also a very good, it's a very solid defense. I think I pretty much covered what I wanted to discuss now. I want to keep this short, and I will do subsequent videos. And I actually want to get into the case of Watts, Barrington Dean Watts versus State of Maryland. the 2018 case. I'll do a subsequent video and discuss it a little bit further. Um, so, if I think of something more regarding intent to frighten assault, because it's a big one in Maryland, and especially, with the ICE raids, we're seeing that, sometimes, and it's wrong, police officers entrapping, violating the rights of citizens who are protesting. Protesting is your First Amendment rights, right? So it's not a criminal activity. But when we're having law enforcement now being violent with protesters, just exercising their constitutional rights, and that's an issue. So I guess that's where you want to be able to focus on the modalities of assault and things that you could be wrongfully charged with, and how to defend yourself. Lawyers very expensive, by the way. What I'm saying does not constitute legal advice. I'm not licensed to practice law in the state of Maryland or in the US. I have a law degree. I hold a Juris Doctor degree. That's a doctor of law from George Washington University Law School in Washington, D.C. And of course, I also have, I completed a program in international human rights law at, from the University of Oxford. That's Oxford University in the United Kingdom. I also did criminal law and intellectual property law at Bocconi University in Milan, Italy. So Juris Doctor means a teacher of legal knowledge. And so I guess while I'm waiting, I'm being held wrongfully under false charges, a malicious prosecution in the state of Maryland. I realize I'm not the only one who's experiencing this, but the thing is, I'm trained to be able to offer a defense, and so I'm sharing my knowledge with people who have time to listen. My name is Olu Osha. I'll keep you posted. Thank you.